Hi, everybody. Welcome to another episode of Bots and Billables. And today I'm very happy because I'm joined by Damien Real. Those of you who do not know Damien, you have missed something. So this is why he's here. And I'm grateful for that. Damien has a career. You're a lawyer, but you're also a innovative product person. You have a deep understanding of technology. And of course, you have hobbies that are remarkable. So Damien, over to you. Thanks for joining. How did this all start? How did you end up being in the eye of the storm?
Sure. I'm a lawyer, been a lawyer since 2002, and I litigated with a big firm where I represented large retailers. I also represented victims of Bernie Madoff and sued JP Morgan over the mortgage-backed security crisis. So I have a history of high stakes bet the company litigation. But strangely, I've also been a coder since 1985. I would anyone who works with me say maybe the worst coder they've ever seen, but a coder nonetheless. So I programmed websites and built, did all sorts of JavaScript and all sorts of things in my youth. So the law plus technology has always been something that I've been really thinking about. And so since 2015, so it's been about 10 years now, I've been in legal technology, first with Thomson Reuters. And then I did a dalliance with Facebook where they hired me to investigate Cambridge Analytica. So I spent a year of my life on Facebook's campus. And then, that was actually after a 14-hour workday. One of my hobbies is music. My bachelor's degree is in music. So at the end of a 14-hour workday at Facebook, I said to my buddy Noah, I said, "Do you want to break music?" He said, "Hell yeah, let's break music." So we've copyrighted 471 billion melodies through brute force, and it's you could brute force a password by going A-A-B A-A-C. We did that with music, where we went da 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 re da da mi da da fa till we mathematically exhausted all the melodies that have been and ever could be. So after my TED Talk on this, which has been seen a couple million times, every defendant in those cases before my TED Talk has lost. Every defendant after my TED Talk has used my arguments and has won. So that's a little bit of hobby. Another hobby I have is that Sally, the legal data standard that I helped lead from 2020 to about 2025, we've taken it and it's standardizing legal data between tiny companies like Thomson Reuters, LexisNexis. I manage NetDocuments. All the biggest law firms in the world and all the biggest corporations in the world are all standardizing around this legal data standard that is using the same language for the legal data. And then with my day job with VLEX, and we just got acquired by Clio, I help product, that is, I help be able to build the things that are going into our customers. And then I talk about the stuff that my team has amazingly built. And so it's maybe the best job in legal technology, where I'm able to both leverage my subject matter expertise in litigation and also my expertise in the legal technology sphere that I've gathered over the last 10 years, and then also be able to really essentially be able to spread the gospel of smart legal data structure. And so between those two things, I think it might be the best job in the world.
There's so much to double click on. Like, there are so many questions I would love to ask as a follow-up question. I can't do that today. We'll get to that later. But Damien, my number one question is, you said you entered legal tech in 2015, and now we're 11 years later. What's the number one thing that has changed if you compare the last decade?
Sure. When I first joined in 2015, of course, all people in all legal technology had to, like subject matter experts, would have to say, "Hey, coders, here are the requirements for the software. Right. I want to be able to, spend months building up the requirements in a waterfall fashion, and then send that over to the coders, who would then code up that. That process would take years. That's the old world. The new world is the code is the requirements. That is, the subject matter expert is essentially prompt engineering to be able to say, here are the requirements, here's what I want, here's what is legally required for this type of document in this jurisdiction. So because the coding is the requirements, we can now iterate so much faster than we ever could in the past. That is, we can be able to crank out workflows and tasks within those workflows in a matter of maybe days rather than the months or years it used to take in the past.
So you say this being one of those people that combine both domain knowledge bases in one brain. You're both a coder and a lawyer, and you say now this skill has become more mainstream because the barrier to actually express yourself in code has been lowered.
That's right. And if you think about all the entrants in the legal tech market space, a lot of them are people that have no legal domain expertise. They're just coders that say, "Oh, the LLMs are really good at words, and the law is all words, so we just let the LLM sort things out." And that's at least the premise that they start out with. But then they quickly realize that the legal domain expertise is the missing piece. That the large language model doesn't know what happens in closed door meetings. It doesn't know what happens in negotiations with the other side or with the judge or with closed door negotiations over contracts. So that subject matter expertise and the knowledge of who needs to do what in which documents, that is the missing piece that legal tech companies can either rely on their customers to do it, or they need to hire subject matter experts to be able to do that missing piece. So I think that legal tech people, one, know the subject matter expertise is important, as I've said, and two, they quickly realize that data is important. That is the cases, the statutes, the regulations, the motions, briefs, pleadings. That data you need to get from somewhere. So between those two, I think that that's the biggest realization that legal tech companies come to.
I think this was the fast-paced entry into the subject we've ever had, by going from "Hi, how are you?" into "Here's a rabbit hole. We're gonna dive right in." I love.
Why waste time?
I love this. You said two things. So one was more on the level of let's say functions or app layer, and the other one was the data layer, like the foundation of the reasoning. Just to double click on the functional part, the hard learning at Brighter was that, starting with the term no code and making the ability to express yourself widely available, and then learning that it's actually, even if you're functionally able to do this, there's a domain expertise necessary to actually do it properly, like puts a limit and a cap to that, brought us to the experience that actually there's a specific role who will do that, like legal engineers. Do you think that we have a similar situation now where people, the discussion about vibe coding, the discussion about being able to prompt, that the intermediate language, the pseudo code of prompting, is a similar sort of like very limited space where people can express themselves before this should actually be handed over to people to actually really know and have the domain expertise of knowing how databases work and how the data structure work and how additional things work that you need to attach to this to really make it work? So to summarize the question, is this really the democratization of allowing people to build, or is this a thinner layer where people will still be on a slightly more powerful but nevertheless very thin layer to interact?
I think what you've asked is the literally $1 trillion question that is not just legal expertise, but I think the entire world economy relies on. And I think that this is, do we need, I think if I can synthesize your question, do we need subject matter experts plus technical people? And is that me as a subject matter expert throwing it over the transom to the technology people? Or is it me working very closely with the technical people in an iterative fashion? And I think that maybe it's number two. I think it's maybe that that I can throw it to the coders. The coders can maybe go back and maybe there's an iterative process in an agile way, and maybe that's the future, and maybe the present. So I think that we really need to be able to have this subject matter expertise. And what I've been thinking about a lot is people are subject matter experts in their very narrow domain. So even within law, you have antitrust experts, and not just antitrust experts, but antitrust litigation experts, which are different than antitrust advisory experts, or different than M&A antitrust experts, right? So these are all different narrow rifle shots of expertise. So I think what is incumbent upon legal tech vendors like you and me and everyone else out there is to think about, okay, what is more normalizable, that is for a complaint, for example, in litigation, or a contract? What is the most generalized version of a complaint? Because there is a complaint and maybe a workflow for a complaint. And do you have a different workflow for an antitrust complaint, or a trademark infringement complaint, or a patent infringement complaint? Are those different things, or are those just variations on the theme? And can you be able to create a generalizable complaint workflow? And do you even need a antitrust version, or a trademark version, or a patent infringement version? And I think that the danger with subject matter experts is, if you're an antitrust litigator, you say, "Oh, no, my thing is very special. You can't be generalized as a complaint. My complaint is far different than a family law complaint, or is far different than a breach of contract complaint." But by narrowing into that sub specialty, I think you lose generalizability. So I think that the losers will create millions of these little tiny granular things, and they'll miss the forest through the trees. That is, they'll miss the complaint forest and focused on the antitrust and patent infringement trees.
Yeah. You're describing the core problem of legal tech. Oh, because having to deal with a market that is many, many sub-markets, but then again is maybe not too many submarkets where you just like have to stop. Like maybe this is a tool for litigation, but maybe there's not a tool for commercial litigation in a specific geo. Like the fine-grained tailoring of that.
That's right. And I think that we as coders have dealt with this with GitHub, where we have version control, right? If somebody will create a repo, and if I say, well, that kind of suits my purpose, but I want to fork that repo to be able to do my small thing. And then maybe I push as a pull request back into the original repo. So we've done that in coding for years, decades. And I wonder if legal tech maybe should adopt the same thing, that there is a complaint repo. And then if I do an antitrust complaint, maybe I fork that and be able to put my antitrust spin onto it and maybe do a pull request back into the master to be able to say, okay, this is now the new, better improved complaint that includes my antitrust variation.
Oh, I love that thought. But the immediate reaction to this is again that this problem asks for a UX. And the moment you have a UX to allow people to basically do this properly, you end up with the first UX you basically build for that use case. You start verticalization and you start making something a little bit more custom. And then the journey again begins to what extent this becomes like sliced down. I had walking through ILTACON, we have the fastest growing legal tech companies ever, like Harvey exploding, just going up. VDEX, I think you saw tremendous growth as well. People always talk about Harvey because that's the new brand, but you have seen tremendous growth, and you had the biggest. Is the acquisition the biggest ever?
I've heard it is. Yeah, $1 billion is a lot of money. Yeah, I don't know of any legal tech acquisition that's larger than $1 billion.
No, yeah, I like it. No, but maybe you had like some category where you're like technically, I don't know, Clio, thinking like there are some M&A movements in there that were like technically bigger. But I think, and then somebody comes up with like, this weird company that then suddenly counts as legal tech, and people go like, oh, actually Palantir is the biggest legal tech move ever. And like, okay, come on. But no, so I think it's the biggest exit ever. And it proves that if you were horizontal enough, you had a lot of market to grab. Do you think that will continue? Like, do you think we already go into the stage of verticalization where people now suddenly have a tool? I don't know. Give a shout out to whatever Waxler AI suddenly is a like Harvey, but for litigation. You have tools specifically for IP research. If you walked around ILTACON, I think there were easily 100 vendors going super vertical. What is your perspective? Is the market big enough for the horizontal platform, or will it already scatter into little pieces that will represent the heterogeneity of the legal market?
Of course, the biggest horizontal platform is OpenAI and Google's Gemini and Anthropic's Claude. Right, that is the most generalizable thing. So the real question for all of the other companies that you just mentioned is, what can you do atop the foundational models to be able to do something that is more valuable than what they do alone? And I think that as OpenAI and as Microsoft and as Google and as Anthropic keep running as fast as they can, I think the gap between what those companies you mentioned are providing and what OpenAI themselves can provide and what Microsoft and Google can provide, I think the gap is shrinking. And so really, I think we need to keep thinking about, okay, what can we do from a verticalized fashion that is something that OpenAI will not chase anytime soon, or that Google will not chase anytime soon. And that is really going to the workflow of the lawyer. That is, I could be a prompt engineer with OpenAI and do that. That's option one. Or option two is I spend a little money on the tool that actually makes me not have to be a prompt engineer. I simply upload this PDF and it does the work that I want to do without having to be a prompt engineer. So there's value to option two over to option one. And the question is, how fast will we be building that application layer on top of the foundational model layer? So that's we'll call that point A. Point B is people find quite quickly that, as I mentioned earlier, you need data. You need the cases, the statutes, and the regulations, because the law, everything in the law is applying your client's facts to the cases, the statutes, and the regulations, not just in the United States, but in countries worldwide. So you will quickly find that if you just merely create that application layer on top of the foundational models under point A, you'll quickly find that under point B, you're missing, is Roe v. Wade good law? Because the foundational models don't know that Roe v. Wade has been overruled by Dobbs. So you quickly reach a brick wall to say, gosh, I need the cases, the statutes, and the regulations. And I think many have found that.
Yes, I have many questions on the data. Let's just continue talking about the data, and let's ask the other questions on the market and the consequences later, just because we're already here. Like, the one thing I'm wondering currently, is um, if you think about this whole thing, you realize that as you said yourself, like one of the few things that you can actually own is either you're a repository system and you have the reach and the build out around that. Like you're a repository system with a database, DMS, and all that stuff, then you have like all that and you can work with it. That's also good. But if you don't have that, you want to have data. That's like your actual real IP. And in the old world, like remember the real AI flywheel was build a cool product with a small team, then give it out to people. It got better and better. It generates more and more data. With the data, you build the better product, and that better product gets you more reach, and that has more data, and that exponential flywheel actually gets you up. And this is why actually venture capital should exist at all. Like that's the whole point. And with the new models, we're all building on the shoulders of giants. So the people that have the IP are the only ones that actually have a verticalized IP actually to work with. So I see a pattern that is weird. People know that, so the people basically start to build around the data they have, but then they realize it's not enough and they need to plug in other sources. So everybody needs additional data. Everybody knows that, everybody tries that. At the same time, people are not open to really share, and people are like being closed and partnering around that. Is this moment we're in where people are trying to create something with the data they have and be protective about that versus being open and sharing everything so we can collaborate? Is that just something that is currently a sign of a super early market that isn't super mature and everybody is scared of how much data the model itself will actually have and maybe pull in itself? Or is this very smart to do and fight a battle over every data repository that we have and not give it away at all and be super protective about it, because you will bite yourself in 2 years that you opened up too early? What's your view on
Yeah.
that?
So I think, yeah, there are two types of data. That is public data and there's private data. Public data is the cases, the statutes, and the regulations. And the private data includes stuff in your document management system, your DMS, in your knowledge management system, that is know-how, how to do things. And the third that people forget about in private data is within lawyers' brains. That is, there's a lot of knowledge that the lawyers, why do I hire a lawyer? It's for what's stuck, locked in that lawyer's brains, that I want to be able to say, hey, in deals like this before, or in litigation like this before, what has been your experience across this? And often that doesn't reside in the knowledge management system. That doesn't reside in the DMS. That just is stuck in the lawyer's brains.
I mean,
So as we,
in a perfect world, it would be in KM, but it's not. Let's assume it's not.
but it's not, right, because lawyers are quite busy and lawyers are quite expensive, and so getting that knowledge from that lawyer's brain into an artifact for the knowledge management is quite hard.
Yeah.
And so when you think about, so let's talk about both public and private data. So public data, public oil, it should be free. And the word public is actually a misnomer because it's not truly public, because it's often behind a paywall. In the United States, PACER, which is the litigation system, to download all of the motions, briefs, pleadings, complaints, et cetera, to download all of that would be about $2 billion with a B. Behind a paywall that you have to pay the courts to be able to get $2 billion worth of that data. So that public data truly is not public, it is private. And so the US courts have appointed me part of a 12-person committee, a user group, to be able to say, how can we make PACER better? And they were talking about things like, how do you do the drop-down menu? And how do you do this? I said, no, don't worry about drop-down menus. Don't worry about buttons. All you need to do is one thing: make it free. Because if you make it free, then truly public data will be public. And then all the legal tech companies can do what they want with it. They can be able to make their own drop downs and they can make that. But that $2 billion public data needs to be truly public. So for now, though, there's only 3 companies in the world with comprehensive cases, statutes, regulations, and PACER data and state court equivalents to that. And of course, those are the big 2 that you know, and then VLEX. And so that's that. If that were to change, that would drastically change things. So that's the public sphere. Now let's move over to the private sphere. DMSs are good, but they don't have all the knowledge management things. And sometimes the knowledge management is in a separate repository from the DMS. And then how do you take stuff from the lawyer's brains and put it into knowledge management and DMS? In the old world, you'd have to have a knowledge management professional ask the lawyers questions. And then they would, the KM people would take notes. And that takes quite a long time. But these days, everyone has this in their pocket. They can record these conversations either through this or through Zoom, and then you can transcribe that recording. And it's much more quickly to be able to turn stuff from the lawyer's brains into a KM resource, because you can put the transcript into a KM system and say, you're a professional knowledge management and you want to be able to extract every node and edge between the nodes of everything that matters to the law, and in a Sally kind of style or folio kind of style. And you could do that quite trivially now. So now I can just have a conversation with the lawyer quickly and quickly transcribe that into the things that matter that in the private oil. So anyway, so I think that the winners are going to be people that can take that brain data and put it into an artifact that the large language models can parse. But the tricky part is that is maybe the most valuable thing that lawyers have left, the stuff in their brains. Because if I'm a lawyer that's thinking about jumping ship to another law firm, why would I give the old law firm all of my valuable data, the stuff in my brain? Because I want to take that with me to my new law firm. There's monetary value to the stuff in my brain. So is the law firm going to pay that lawyer for the transfer of value from their brain into the repository of knowledge management? And I think that is going to be the primary question: is how much value is it to that? Because in the end, we all know where this goes. People think that clients buy widgets, that buy the merger documents, or they buy the documents for litigation, but they don't buy the widgets. They're buying trust. And buying trust, because the large language models are going to crank out the complaints. They're going to crank out the contracts. But what I, as a client, am hiring you as a lawyer for is to trust you to say, in deals like this or in litigation like this, tell me, am I doing the right thing? That trust is stuck in the brains. So really, as large language models and tools like ours crank out more and more of the documents, all that will be left for lawyer value is trust, what's in my brain, and sales and marketing. We are salespeople. We are salespeople. Rainmakers are salespeople. They don't like to think of themselves as salespeople, but they are. And so the salespeople are going to say, here's the stuff in my brain. Trust me for this. And so for a lawyer to give up that is probably worth money.
Wow. So first of all, that's a super interesting thought to rethink the almost employment legal relationship of a lawyer and their firm and the people responsible for the knowledge management there, because you could argue that the experience of the lawyer is maybe something that they want to keep for themselves. This is it's also a wild thought. We have to think about this. But I love how you say that basically I call it the asset of the data of the legal thing is worth nothing without the trust in the people to actually evaluate it. So there's this funny story I told before of a lawyer who told me that it was a partner of one of the big firms in Europe who had a library, and they had one of the biggest library that was like not a university, and they thought clients would actually take them as a firm, because they had invested so much in that library that they were able to provide all the cases when people were asking. They would actually go downstairs and they had a million buried in Capex there in like books and leather-bound stuff and find the answer. And when all the research, the online research system came, like Hein Online, Lexis, Westlaw, and the European ones, you had you gave clients the ability to actually access this for $100 a month, and the USP of the law firm of performing that research deeply was sort of gone. And the law firm at that point was apparently scared they would lose the clients, because the clients wouldn't actually call them up for the research anymore, because they could literally do it themselves. And these were even the same associates that had been working at the firm before, so they had just transferred and changed ship, and now they were like working at the big car manufacturer doing exactly the same job, but now just like asking the query and getting the info. Turns out nothing changed. Like, information is free all the time. There are NDAs online, there are lease contracts online, everything is online, available free. Legal assets are free. And people who don't understand that, it's just like Google. It's the same effect that Google had, that it would give you wrong advice or right advice. You didn't know. You needed a lawyer to tell you whether or not this was correct. So the funny thing about this is that we're now, again, tapping into free legal knowledge resources, but we need somebody to interpret it. And I find it so funny that people always destroy, like, I asked my lawyer and it was like $300 for a 30-minute phone call. And then I asked GPT and it was the same. Well, you only know that because you had both data points. Like, would you not do this? Like, would you stop using a lawyer in your company just because you use ChatGPT? No, you wouldn't. I don't know. Maybe you will in 5 years. That's the big question of, can we build the trust towards a brand the same way we can build towards a person? That's like one of the funny, developments, because ironically, if I'm honest, I think that the relationship of a client towards their lawyer is a similar relationship of the lawyer towards the publisher. Like the logo of the publisher and their peer review and the fact that they have it in the database and like double checked it and selected it and had all this process is similar. So if a lawyer in a law firm trusts a logo of a publisher, could you erase that middleman to have a person trusting a logo? I mean, it wouldn't be the same because in that charge, but could we do that?
So I think there's two aspects of this that are quite important that you just touched on. The first aspect is, of course, lawyers think about lawyers and law firms as centrally, but they should be thinking about their clients because their clients have in-house counsel. And right now, Salesforce was on stage with me at ILTACon, and they said to the world, they said, hey, already this year, so in 2025, up through July, we've saved about $3 million in it, but that we would have done external spend. We brought that in-house. And we brought that in-house using things like Vincent and other methods. So that, and they think annually by the end of the year, that's probably going to be $5 or $6 million. And then they're looking to expand that next year in 2026. So I think that, so number one is shift is already happening where internal counsel, in-house counsel, law departments are bringing external spend in-house and doing this faster, better, stronger. Because option one is to ask their lawyer, which is really expensive and takes a long time. Option two is to ask things like Vincent and then get a really good answer and just move on with their day.
But what you're basically saying is that Vincent could be the brand to be that.
Maybe. And it really goes to trust. That is, do you trust the brand? And we used to trust treatises, right? But in the old world, think about what a treatise is. A treatise is merely a commentary from a professor or someone on the cases, the statutes, and the regulations, saying this is what the law is, and this is maybe where the law might be going. That's the old world, though. You trusted those treatises. But really, between the old world, where maybe that's updated annually, Vincent gets updated every day. That is, we have yesterday's case. We have yesterday's statute. We know that this has been overruled. So we have more updated things than the treatise. And number two, like if I have a case in litigation, for example, that includes antitrust and patent infringement and trade secret, these are three different treatises that I, as a researcher, have to go to page 357 of the antitrust case. And then I have to go to a different book to page 462 of this, right? So that's the old world. The new world is, LLM-backed tools can just be able to bring all this together to say, here are my facts. Here are the patent things, including the case that was just decided yesterday, antitrust things, including the case decided yesterday. So this is a custom treatise, almost like a me-tis, right? That is focused on me. And so really, in the old world, we trusted treatises, but in the new world, I guess you'll maybe trust a large language model better because it has more updated information and is maybe more customized to my facts. So I think the trust in treatises maybe has gone by the wayside. Maybe secondary materials these days will have less importance.
Wow. So you're one of the, I would say, most balanced people in the space who still are in the know, and you don't have an extreme view, but that is an extreme view though. So I just flag that. This is the treatable bit where you say maybe yes.
So maybe extreme, but maybe reasonable. So if you think about what we talked about earlier, that there's the cases, statutes, and regulations, and there's what's stuck in my brain. The secondary materials in the past have been what's stuck in that professor's brain, and then that lawyer put it into an artifact. So this is the know-how on how to do antitrust things, or the know-how on how to do patent infringement things. And so really, this is just a continuation of that know-how, old world treatise. New world, either you rely on the Harvard professor to do that, or you have your lawyers in your law firm put that knowledge in their brain into this.
Nice. No. This is super wild. I have a follow-up question just on the market consequence for this. You mentioned Salesforce, but if you look around in the in-house teams, what is your canary in the coal mine? What is the data you look at to see where the money is going or whether the change is real? There's 4 more times people call you up and say, I want AI, but the data of this actually having an impact. Is there something you look at specifically? And if you do, what is your view on this?
I have several canaries in the coal mine, one of whom's name is Leo Mergel from Salesforce. Another is Darth Vaughan from Ford Motor Company. These are canaries that are pushing the industry. And Darth Vaughan has said, I saw him at Bonnie Doon I'm going to be seeing him again, but he said to a bunch of firm leaders and a bunch of legal tech leaders, he said, law firms, your biggest competitor is me. I'm looking to eat your lunch. I'm doing a lot of things I used to do to you. So I'm bringing all this work in-house. So you've got to demonstrate, number one, you're using a large language model. If you're not, you're fired. Number two, because you're using a large language model, you're competing against me. What can you do that I can't do with my in-house team? So really, I think that those are the canaries in the coal mine. Leo Mergel, who is saved now, expected to save about $5 million this year, and Darth Vaughan from Ford Motor Company. These are canaries in the coal mine saying, of course, not every in-house counsel is this forward-thinking, but there's a saying that the future is here. It's just not evenly distributed. And I think that they are the future and the present for them. And I think that will just continue to go widely across the industry.
Yeah. Okay. Very interesting. So it is all eyes on the corporate clients.
That's right, because the corporate, if you think about how much legal spend is in the United States, almost, a huge majority. And Jay and Ed Sohn know this data better than I do, but I think I remember something like 80+% of the legal spend is from corporations, not people, humans. So anyway, so I think that where Leo Mergel from Salesforce and where's Darth Vaughan from Ford Motor Company, where they go, I think the industry will follow. And then there's the consumer market. That is the humans. People call it people law. That is, I need to get a divorce, or I need to be able to deal with this, my landlord, right? This people law is a huge untapped market because 92% of legal needs are unmet because we lawyers are too expensive.
Yes.
So economists would call that an untapped latent market. And what if we could tap that untapped market to be able to say, let's use a large language model to shrink the traditional cost of legal services and go directly to consumers? That is, of course, it has historically been prevented by the unauthorized practice of law statutes in the United States, but there's no such statute in the UK. And a lot of other countries don't have unauthorized practice of law. And even in the United States, Arizona has said that non-lawyers can own legal law firms, ABSs. And so I think that direct-to-consumer is another big market beyond the corporate market.
I agree with you. I think the direct-to-consumer is interesting, especially because AI allows you to work at scale in areas where scale was almost impossible. First, because it was regional, it was small, it was like case by case, and also you didn't have the ability to create a brand in a way because it was human touch points, and the human touch points were limited. Like ironically, if you go to a big law firm, the trust in the brand of the firm is almost as big or similar than the trust in the lawyers. Like you trust your lawyer because you've been working with them for maybe decades in your company, and this trust reflects into the law firm's brand. So like I don't know, DLA Piper, Skadden, Latham, they all have great brands and trust in these brands. The law firm around the corner is almost unknown and it doesn't have that. And I would even argue that the touch points of people going there with not their lawyer, but a lawyer, are so rare that they don't even create trust that much. I wouldn't even argue that in most cases, B2C law, they don't even care who they talk to. Like yes, I mean, there's word of mouth for your divorce lawyer, but you have the interaction once, you buy that house once, you then go away, you don't care. This means like you couldn't really build a brand. The irony is that using technology, especially AI and knowledge base and the abilities of marketing and like building that out, you can build that brand for the first time. So you could build a trusted employer brand in legal and doing that. And there have been, I think, tests in every country going back in the last 10 years trying that, and most of them failed. Do you think this is the time where this could work now again, for real?
Maybe. And one reason it might be different this time is because if we in the United States, if we want to really protect the consumer from the evil non-lawyers seeking to do them harm, then we should definitely sue OpenAI for ChatGPT. We should definitely sue Google for Gemini. We should definitely sue OpenAI for Anthropic or Anthropic's Claude, because who is committing more harm to the public than these massive companies? And, Sam Altman was talking about how a huge percentage, in his words, of questions to ChatGPT is for medical advice. He calls it health advice, right? So are they committing the unauthorized practice of medicine? And I would like to ask Sam Altman, how many of the queries are legal advice that is being asked of them, right? And I would say probably millions of queries, maybe a month, are being asked of legal questions. So that is, so I think the reason it might be different now is because Google and OpenAI and Microsoft and Amazon are kind of accidentally entering this area. And when I spoke with a massive legal tech company whose name that I'm not going to say, one of my friends who works for that company said, if Google wanted to squish us, they could in an instant. They could squish us, but the legal tech market is just too small for them to worry about. That Google is thinking in the hundreds of billions of dollars. They're not thinking in the a few $billion that the legal tech market is. But right now, Google's in that market. They just didn't know it. It's almost like an elephant squishing an ant, where they just didn't realize that they're stepping on legal tech. So I think that all the legal tech players need to think about that elephant that is Google
Yes.
and Microsoft and OpenAI, squishing them accidentally.
The irony is that, this is all the let's say, the intransparency of the power of the tool. You had a normal Google search, and nobody cared about the fact that this could actually provide legal advice in a way, like maybe even better than a lawyer. You then had, ironically, a wave of tools that were like, the rule-based self-service tools that would sort of give you the ability to generate a document. And if you add some reasoning on top of that, there were people being disallowed to publish that because it was actually legal advice. Ironically, just because you would sort of anticipate some of the questions and put this in an anticipated model and just like had people ask it with a, like, I want to say, steampunk style automation, if this then that, however, containing a simple ontology of how that reasoning works. So now we make this intransparent and we add it to Google, and suddenly you could argue you have a lawyer, or you could do the exact opposite, argue you have a search engine because you can't know how powerful it is. And I think we will have the irony is that if a lawyer uses that, just empowers them, and you have like this person as the human front end, but the AI in the back, that would be fine. If you flip it around, it's not fine if you say it's legal advice. So I don't know the US jurisprudence on how that went in like where you were allowed to use it, but the many European countries, Germany, the UK, same. It was about the labeling. If you called it legal advice, it was bad. If you said it's not legal advice, it was fine. Like putting a disclaimer there saying this is not legal advice. This is not a pipe. You were
Yes, the biggest difference is between what is legal advice and what is legal information. Because legal information is cases, statutes, regulations, and secondary materials like treatises. And that line between legal advice and legal information has never been clear. And large language models obliterate that line. Because in the past, it used to be, okay, a treatise is legal information, say 1,000 pages of secondary materials. And then legal advice is taking your client's facts and applying that to the cases, statutes, and regs. But large language models are happy to apply those facts to the law. Excuse me. And so really the line between legal information and legal advice is completely obliterated. And so really, if you were to take a secondary source, say 1,000-page treatise, and if you were to say, here's page 3, page 400, and page 752, which apply to your case, does that magically turn that treatise's legal information to legal advice by merely selecting those pages? And the answer is no. But that's exactly what a search engine is. That is exactly what a large language model is selecting the particular pages from that legal information. And it doesn't magically turn that into legal advice, like some kind of quantum particle where it's legal information here, but legal advice as soon as you run a search engine over it. It's always been legal advice. Or I'm sorry, it's always been legal information.
Yes. Yes, but the interesting thing is that there's on this spectrum, suddenly it tips. Like the moment you then say is like, if you, I don't know how Vincent works in detail, but like, these AI assistants have the references. Like you get a reference for where you find in the document, you click it, it jumps there, it gives you this chunk piece and it shows you where it is. You have this, like making the chunk smaller, making a summary of the 3 chunks, and you're already at what a lawyer would put in your email. And where do you draw the line then? Like, where is it?
That's right. And really, when I think back on my 15 years of litigation experience, I think back and I had this revelation about a month ago that how much of the work that I did every day for 15 years was legal information and not legal advice. We think that we're giving legal advice, but I would often say, here are the statutes at play. Here are the cases at play. Here are the risks you have. That's all legal information, right? But then they would say, Damien, what should I do? Legal advice. And I would say, hey, that's a business decision. What's your appetite for risk is up to you. So you can make the decision, what's your appetite and do you do it or not? That's up to you. I'm going to give you the legal information. So a huge realization for me is how much of what lawyers do every single day is actually giving just legal information and not actually giving legal advice, because they're not actually telling people, because once you start down the advice route, you can get sued for malpractice.
Right.
So there's a disincentive for you as a lawyer to give advice, because advice puts you on the hook for malpractice. But information, man, this is just information. So really, we have to think about as lawyers, should we be giving more advice? Because that's all that we have left, because the large language models can provide legal information if they have the corpus of the cases, statutes, and regulations.
Yeah. And you go towards the circumstantial application of the information, right? Like what does that mean for you now in that situation you are in with the facts you gave me? for some of the courts, this was the differentiator to whether or not these systems were actually providing advice. Like, is this circumstantial? And the irony is that it weren't for some of the cases because it could only anticipate like some very simple rules and like anticipating a situation. And you had to do the application of the law yourself by basically saying like, am I a vendor? Am I in that situation? And then you basically select. But I'm not sure. Yeah, no, like look, there's nothing to add. This is very, very interesting, and it's going to be impactful to many people who have ideas for individual assistants, agents, solutions in the space. It's bringing me to the last question almost because we're talking, like I said, there could be a lawyer front end would solve all the problem. If you have a lawyer front end with AI in the back, this is not a problem. You go wild. Don't you think that it is currently the lawyers equipping themselves more with the tech rather than you have the clients being corporates or not corporates actually getting the picks and shovels to dig for gold themselves? So is based on the idea that if you have the technology, you're the one who benefits from it exponentially more than the others. Don't you have a feeling that it's the lawyers who will serve that wave because they are the ones who see it, buy it, test it, and they are the ones who are bringing the application. So there's almost like more legal advice at scale in better ways before any of the pie gets actually taken away through other means.
I think that depends on how quickly the lawyers move. Because Google is moving very quickly, so is OpenAI, so is Anthropic. They're all moving quite quickly to be able to capture market share, what they see as a generalizable tool, but is accidentally an elephant stepping on the ant. And so I think that consumers are already asking millions of questions of ChatGPT, legal questions of ChatGPT. And so I'm gonna pull this book by my friend Sean West. It talks about the rule of law kind of going down. That is the rule of law worldwide, and especially in the United States, is really in decline. And so his point is a good one: is that statutes, rules are only as good as their enforcement. If a statute or a rule is not enforced, what's the point? And so if you're competing with somebody, say you're running a race with them and or driving, and I stop at every stop sign, but my competitors roll through every stop sign, they're going to win, even though they're breaking the rules. Mm-hmm. And the question for the competitors is, how many stop signs can you run without enforcement? And so applied to the question you've asked is, okay, there is an unauthorized practice of law statute, right? But who's going to enforce that unauthorized practice of law against Google, against Microsoft, against Apple, against OpenAI, right? And nobody's going to, New York's not going to sue Google and Microsoft and OpenAI. California's not going to. So if there's a rule on the books that is never enforced, maybe the unauthorized practice of law goes away, not with a bang, but with a whimper. That is through non-enforcement, because everyone's doing a running stop sign. And so if they're not going to enforce against Google and Anthropic, if you're a small legal tech company that says, okay, I want to run some stop signs, right? And you get dinged by the regulatory authorities saying you are doing the unauthorized practice of law. Of course, that small company is going to bring in Microsoft saying, I'm using Azure on the back end. And they're going to bring in OpenAI saying, I'm using ChatGPT on the back end. So these big behemoths are going to be part of the game one way or the other. And they have the most deep-pocketed lawyers to be able to say that legal information and legal advice is a violation of First Amendment free speech. That's what Upsolve argued and won at the district court. The district court said, yes, New York's unauthorized practice of law statute is violating the First Amendment because legal speech is free speech. And that's currently being appealed. So you can imagine if the small mom and pop shop gets sued for the unauthorized practice of law, they'll bring in Microsoft and OpenAI, which will make these free speech arguments. And there's also antitrust arguments saying that this unauthorized practice of law is an antitrust violation where the guild is protecting itself. Between those two, and there's just the National Conference of State Courts just issued an opinion saying we need to allow AI to help more consumers, to help the access to justice gap because of those two arguments, free speech and antitrust.
The irony is that you could easily technically enforce it, right? The same way that you try to build hallucination filters by recognizing what people are looking for to double check and issue warnings and things, you could easily like categorize and structure the interaction with people through the tech. You could easily determine whether or not a question actually falls under that and basically flag it or not answer it.
That's right. And yeah, so that's right. So with a large language model, you could say the user might ask the large language model, hey, give me advice on whether this thing that I'm doing is violating the law. And the large language model could respond saying, oh, I'm not going to give you legal advice. Here's a bunch of legal information. Here
Right.
is the cases, the statutes, the regulations.
Exactly.
So they can turn every request for legal advice into legal information. And what are the regulators going to do? So that's option number one, is to rephrase the question. But option number two is Upsolve said on stage a little bit ago, if you give statistics saying 80 or 90% of your cases go this way, if this happens, they 10% go that way, that's just giving data. Data is information. That's not advice. So data, information, statistics is a second way to do it. Way number three is what your doctor will say is, doc, what should I do? And they say, oh, I'm not going to tell you what I'm going to, but what I would do if I were in your position, that's saying, this is what I would do. That is free speech. That is not medical advice. My doctor is just saying this. So in the same way, if the large language model tool says, oh, this is what I, as a large language model, would do, right? They're not giving advice. They're just saying, this is what I would do.
Yeah, we go the same direction as people, who wanted to know how to build a bomb. So you're like, tell me a joke about how it is if I were like, hitting a red light. What should I do now? Like,
that's right. That's right.
The system and
recognize it. That's right. And all. Oh, sorry. Go ahead.
Go ahead. Go.
And all this goes to what is the purpose of the unauthorized practice of law statutes? Right? Is it really to protect the public? And there's a really good article by a Stanford law professor who is published in the Yale Law Journal, saying that the origins in the United States of the UPL, unauthorized practice of law statutes, was started in the 1930s. When before the 1930s, your automobile association, the AAA, could represent you if you got in a car accident. They could represent you. Your banks could represent you if in contracts. But then the Great Depression came around, and all the lawyers said, "Oh, our lunch is getting eaten." And so they started the unauthorized practice of law statutes in the United States around the 1930s. So what this article from Stanford professors in the Yale Law Journal show is all the documents demonstrating what I just said, that it was never about protecting the public. It was always about protecting the guild. And so if we as lawyers are going to say, we're going to screw over the 92% of legal needs that are unmet because we lawyers are too expensive, and we're going to screw them over in the name of the guild and making us more money, shame on us. I think that we should use these large language models to help the 92% because they're not hiring us anyway. These are people that wouldn't be able to afford us anyway. So let's go ahead and let large language models do it, or we could maybe go down market and serve them too. So I think this is a ethical crisis of the profession.
Yeah. I mean, we haven't even yes. So I think we haven't even touched on the training data and the ethical crisis of IP infringements in actually creating them, and the too big to be sued or too big to be acted upon is we just talked about one of the problems. We could probably talk about more. Damon, this is great talking to you about this. Well, I have one last rapid fire question. I asked you this before at ILTA, but we struggled to get this in. What would you invest in if you had $5 million and you had to invest it tomorrow, and it has to be in legal tech, and you can do whatever you want with it? What would you do?
I think I would invest in a company that is structuring data in a way that makes sense. Both public data, that is the cases, statutes, and regulations, and private data within the law firm's repositories, and being able to essentially take what is currently unstructured data and be able to tag it up with Sally and Folio tags, and be able to say, every time a law firm, a lawyer would say to me, well, I would say, what's the law on this? They say, well, it depends. And that's the favorite lawyer term. And every time they say, I would say, depends on what? And then whatever came out of their mouth, I would add to Sally. And I'm currently adding to Folio. So really, I would invest in a company that is collecting all of the it depends, everything that makes the law go this way or that way, to be able to tag up and be able to then say, okay, here are cases like mine, here are deals like mine, and to be able to collect all of that. I think that's the biggest opportunity, because once you have that structured data, the large language models can parse that structured data in knowledge graphs and otherwise to be able to give an even better deterministic view of the world rather than the probabilism of large language models. So if I invested $5 million, I would say, let's build something to clean up data.
Nice. Damien, I think you will probably not do that because you love your job, as you said. This was a pleasure talking to you because I can feel that you do. You love your job. Thanks for joining. Thanks for providing insights into an area that most people will love to talk about more. Thanks for being here, and see you soon.
Thank you so much for having me. Always good talking to you.
Take care, Damien.